Hello, my name is Vedant. I am a legal intern with LEXIS and Company. In this video, we will talk about an important legal update, that is judgment on GSTs on intermediaries, on which the Bombay High Court delivered a split verdict on the constitutionality of Section 13, Clause 8, Subclause B of the IGST Act. Which imposes GST on section states that which imposes GST liability on services provided by intermediaries to person located outside India. While Justice Ujjal Bhuyan has held that the provision to be unconstitutional, Justice Abhay Ahuja dissented. Justice Ahuja said that he will release a separate opinion on June 16, recording his reasons for disagreement with Justice Bhuyan. As per Section 13, Clause 8, Subclause B of the Integrated Goods and Services Act, the supplier of place of intermediary services is deemed as the location of the supplier of the services. As a result of this deeming provision, the services given by intermediaries like agents, brokers, etc. to overseas clients are brought under tax liability. The export of services by 10 intermediary would be treated as intra-state supply of services under Section 13, Clause 8, Subclause B, read with Section 8, Subclause 2 of the IGST Act, rendering such transaction liable to payment of central goods and services taxes and state goods and services tax. So, what were the petitioner's arguments? The provision was challenged by Dharmendra M. Jain, the petitioner, who was running a proprietorship giving marketing and promotion services to foreign clients, contending that the parliament lacks the legislative competence to tax export of services by deeming it as a local supply. The petitioner submitted that his customers have no establishment in India and his consideration was received in foreign currency. GST is a destination-based tax on consumption. Therefore, services provided by a service provider in India to a service receiver located outside India, which is treated as export of service, cannot be taxed. For taxing a service, it is not the place of performance but the place of consumption which is relevant. Once the services are consumed outside India, Parliament has no jurisdiction to levy tax on such services consumed outside India. GST is an indirect tax. The cardinal rule of indirect taxation is that it must be capable of being passed on to the end receiver of the services. Therefore, it is tried that an agent cannot be burdened with GST. The petitioner argument that this tax imposition on export of services is arbitrary and discriminatory, resulting in violation of Article 14 of the Constitution of India. Also, the provision infringed the right to trade and business under Article 19, Clause 1, Subclause G of the Constitution. So, what were the union's argument? That is the central government's argument. The union government argued that there was legislative competence to enact such provision. If the place of supply was to be made the location of recipient, place of supply for all intermediaries located in taxable territory providing service to a person whose usual place of residence is outside India would be the location of the recipient, that is outside India, and thus services would have gone outside the tax net. In matters related to taxation, Parliament has power to create deeming provisions. Greater latitude has to be given to the Parliament or to the legislature while framing taxing statutes, and the existence of power to tax may normally be presumed to be in the public interest. So, the Justice Bhuyan held that the impinged provision runs contrary to the scheme of GST Act. He stated that by artificially creating a deeming provision in the form of Section 13, Clause 8, Subclause B of the IGST Act, where the location of the recipient of service provided by an intermediary is outside India, the place of supply has been treated as the location of the supplier, that is in India. This runs contrary to the scheme of the CGST Act as well as IGST Act, besides being beyond the charging sections of both the acts. The judge also said that the provision runs counter to the principle of GST being a destination-based tax. The judge said that the extraterritorial effect of by way of Section 13, Clause 8, Subclause B of IGST Act has no real connection or nexus with the taxing regime in India introduced by the GST system. Rather, it runs completely counter to the very fundamental principle on which GST is based, that is, it is a destination-based consumption tax as against the principle of origin-based taxation. Having Justice Abhay Ahuja wrote a one-page order stating that he was unable to persuade himself to share the opinion of Justice Bhuyan, and he will subsequently state his opinion on June 14th in a separate judgment, in a separate order. Thank you.